So let's get into the facts of this Viking River case. Angie Moriana was a sales rep for Viking. You know, as part of her onboarding, I assume for a condition of employment, she had to sign an arbitration agreement where she agreed to resolve all of her employment disputes with Vikings in arbitration using only individual procedures rather than class or representative procedures such as PAGA. Well, so she sued Viking alleging various labor code violations and sought to recover PAGA penalties on behalf of hundreds of current and former Viking employees. And, it's familiar to anyone who's been in a PAGA litigation, Viking sought to compel arbitration of the individual claims, and the trial court denied that request, citing the Iskanian ruling, and saying that the individual PAGA claims couldn't be forced to arbitration. The California Supreme Court rejected review of the case, and then Viking petitioned to the US Supreme Court, arguing that the Supreme Court should take up the case and say that Iskanian was wrongly decided and is preempted by the FAA, which, there had been a number of requests since Iskanian for the Supreme Court to take up that issue. Had not done so until December, when the court decided to take up Viking. And so the question before the court was, does the Federal Arbitration Act preclude an employee who has signed an arbitration agreement from bringing a representative PAGA action? And so the question may be, well, Anthony, I'll let you get into the arguments, and then we'll discuss what that means.
And the decision that just came out 2 weeks ago from the US Supreme Court outlined what Viking's argument was. And it said Viking was arguing, the employer was arguing here in this case, that prior decisions, those cases I mentioned earlier, plus some others, have required enforcement of these contractual provisions in arbitration agreements, waiving the right to bring PAGA claims because PAGA creates a form of class or collective proceedings. So they're arguing that AT&T and the Epic case, among others, were binding on the arbitration agreement here because it created this class or collective proceeding which was waivable under the FAA in arbitration agreements. The plaintiff, Moriana's argument was came in and said that the PAGA waiver is a substantive right, and PAGA, it's an actual right that's conferred to the employee, and they can't waive these rights in arbitration agreements. And they tried to characterize PAGA as only increasing the penalties under this single cause of action given to this right of the employees. And the court acknowledged, like, look, yes, that's true. Employees cannot waive these critical rights in arbitration agreements. But and by entering into these arbitration agreements, the employees are just basically agreeing on a different venue and a different process on how to litigate their rights, but they can't waive any rights in these arbitration agreements. And Moriana was saying this is basically a waiver of a substantial right if you agree, if you take Viking's argument. However, the Supreme Court disagreed with both parties and came up with its own explanation on why the FAA preempts the prior law or prior holding here in Iskanian. And I'll turn it over to Mike here for this slide.
Yeah. I just want to, I understand everybody wants, what's the bottom line? What does this all mean? Just want to point out here is kind of how the decision came down, just to show you that it's really complicated and not at all simple. There was Alito who had the majority opinion. He was joined by Breyer, Sotomayor, Kagan, Gorsuch, but then Roberts joined as to parts 1 and 3, and Kavanaugh and Barrett joined as to part 3, and there was a concurrence, and then Barrett filed a concurrence, which Roberts joined as to everything except the footnote. It's just really kind of a lot going on, and I think portends to maybe the Anthony's point that this is, maybe more to come, and not the final word on what's going to happen with PAGA. But let's get into what the court actually said. the court explained that how PAGA is different from class actions, because it has multiple claims, but in a single suit, but different from class actions in that, the plaintiff represents the LWDA, whereas a class plaintiff would represent all the other individual employees. And PAGA suits have none of the procedural characteristics of class actions. There's no certification requirement. The judgment's only binding on the state, not on individual claims. And absent PAGA employees really or don't have a right to intervene in the case per se. And so after laying out the way that it was different from class actions, in the Supreme Court noted, if we go on to the next slide, Anthony, that this sort of weird vocabulary had developed amongst PAGA practitioners that it's still kind of still being worked out, and the court really focused in on this idea of representative actions. PAGA is a representative action, but when you think about what that means, really it's used in two different ways. One, it's representative in that the claim is being brought by an employee acting as a representative of the state, as an agent or proxy. So it's the state's claims, but it's also representative in that the employee is seeking penalties for violations sustained by not just that employee, but other employees. So it's representative in those two ways.